Welcome everyone to our webinar on protecting your brand, commonly asked questions about trademarks. My name is Rebecca Jones and I'm the practice group leader in LegalVision's trademarks team. I'm joined today by my co-host Graci Chen, who is a senior associate in our trademarks team. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides for this webinar in your email. Please submit your questions in the Q&A box and we'll answer them at the end. And please take a moment to complete the feedback survey after the webinar. For the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. To claim your free consultation, please provide your contact details in the survey at the end of the webinar. So today we'll be discussing some of the most commonly asked questions about trademarks. We'll cover the differences between business names versus trademarks and the differences between registered trademarks and common law or unregistered trademarks. We'll look at which version of your trademark you should register, whether that's the word, the logo, or a combination of both. We'll discuss what you can do if the trademark you want is already taken by someone else. We'll talk about how you can stop someone who is copying your trademark. And lastly, we'll look at how to protect your trademark globally. At the end of the webinar, we'll be answering some of your questions. Thanks to those that have submitted questions ahead of time. And if you haven't submitted your questions yet, please submit them through the chat function throughout the webinar and we'll do our best to answer them at the end. And now Graci will speak about the differences between business names and trademarks. Over to you, Graci.
Thanks, Rebecca. All right, let's start by clearing up a common area of confusion for businesses, the distinction between business name registration and trademarks. While they might seem similar, they actually serve very different purposes. So firstly, a business name registration identifies your business or entity, allowing customers or clients to easily recognize and contact you. On the other hand, a trademark is designed to distinguish your goods or services from those of other businesses in the marketplace. It signals to consumers that your offerings come from a specific source, helping to build your brand identity. So from a legal standpoint, these differences are important. A trademark provides you with legal protection, granting you exclusive rights to use the mark and the ability to prevent others from using it. By contrast, a business name doesn't actually give you any legal rights in the name. At most, a registered business name may potentially deter others from reserving a similar business name with the New Zealand Companies Office. So for those of you in New Zealand, it's important to note that there is no official business name registration system like in some other countries. So to protect your business name, you generally have two options. You can register it as a trademark, or you can reserve it with the New Zealand Companies Office when incorporating or setting up your company. Regardless of how you choose to set up your business, securing a trademark for your name is a best practice. It ensures that you have the necessary legal protection and rights over your brand. All right, let's discuss now some practical issues that can arise if you're not aware of the differences between a business name and trademark. Many business owners are surprised to discover that simply registering or reserving a business name doesn't protect their brand. So while your trademark and business name may often be the same, they serve different purposes like we've discussed. A business name registration alone won't prevent other businesses from using a similar name, nor does it provide any legal rights or protections unless you've also registered it as a trademark. Another important point is that when you register a business name or trademark, the relevant government agencies don't automatically cross-check these registrations. This means that you could inadvertently register a business name that conflicts with an existing trademark and potentially infringe on someone else's rights. While there's no automatic cross-check, a great starting point is the One Check tool on the New Zealand government's business website. This tool allows you to check the availability of your business name, web domain, trademark, and social media usernames all in one search. Lastly, it's important to understand the criteria for determining whether a business name is identical or nearly identical to another business name is actually entirely different from the criteria used for assessing similarity between trademarks. So the test for assessing trademark similarity is generally narrower or stricter than those for business names. This means that from a business name perspective, it's possible for two businesses to coexist with very similar names like Star Co and Star New Zealand. From a trademark standpoint, though, the use of these names could lead to one business infringing on the trademark rights of the other. All right, some key takeaways here. So remember that registering a business name doesn't grant you any legal protection or rights. This means it won't prevent others from using the same name. While having a registered business name might suggest some common law or unregistered rights, enforcing these rights can be more challenging than enforcing registered rights, which we'll explain in more detail soon. Successfully registering a business name doesn't guarantee that the name is available for use or registration as a trademark. Before committing to a name, it's really important to conduct thorough checks, so including searches of the trademark register and general internet searches. Simply being aware of existing trademarks doesn't shield you from potential infringement, even if you hold a registered business name. And finally, while there are online tools to help you check name availability, they shouldn't replace a professional assessment. So it's always worth engaging a trademark professional to perform comprehensive searches and analyze any potential risks associated with your proposed brand. I'll pass it back to you, Rebecca.
Thanks, Gracie. Now, the next question I'm going to look at is, what is the difference between a registered trademark and a common law or unregistered trademark? Now, first things first, trademarks can be both registered or unregistered. It's actually a common misconception that a trademark is synonymous with a trademark registration. In fact, a trademark exists as soon as you create it or use it and before you even apply to register it. Now, the strength of your rights in a trademark can vary quite a bit depending on whether it's registered or unregistered, and if it is unregistered, to what extent you have been using it and have a reputation in that trademark in the marketplace. The best trademark protection available in New Zealand is that of a trademark that is protected under the Trademarks Act. And to obtain this protection, your trademark must be registered with the Intellectual Property Office of New Zealand, or IPONZ for short. The Trademarks Act gives exclusive rights to the owner of a registered trademark to use the trademark or to authorize others to use the trademark in relation to the goods and services that are covered by the registration. Now, when we talk about unregistered or common law trademarks, we're talking about trademarks that someone has used in the marketplace to such an extent that they have a reputation in it, which they are legally entitled to protect. As the trademark is unregistered, they cannot rely on trademark infringement, which is provided for under the Trademarks Act, but they may be able to rely on the misleading and deceptive conduct provisions of the Fair Trading Act. Specifically, the Fair Trading Act prohibits conduct in trade that is misleading or deceptive or likely to mislead or deceive. For example, if one trader is using another trader's trademark without their permission. Similarly, an unregistered trademark can also be protected under the common law tort of passing off. Passing off enables a party to take legal action against another trader who makes a misrepresentation, such as unauthorized use of another trader's trademark, that passes off that trader's goods and services as those of the true owner of the trademark. Now, although it's possible to enforce both registered and unregistered trademark, there are significant benefits to trademark registration. First of all, a registered trademark is generally easier to enforce. So establishing trademark infringement involves assessing the unauthorized use against the particulars of the trademark registration as entered on IPONZ's register. So you'll be looking at, are the trademarks substantially identical or deceptively similar? And is the unauthorized use in relation to goods or services that are the same or similar to those covered by the registration? Now, on the other hand, if you are relying on misleading and deceptive conduct provisions or passing off to take action against unauthorized use of your trademark, rather than relying on a trademark registration, you'd first need to establish that the relevant reputation in the trademark exists. And what this means is that you need to provide a lot of evidence showing your use of the trademark in the marketplace to establish that you have the reputation in the first place. Now, obviously, coming with a higher evidentiary burden means it comes with more expense and more effort. A registered trademark also gives broader geographic protection, which is another benefit of registration. So generally, a trademark registration will extend throughout all of New Zealand, whereas recognition of reputation and rights in an unregistered trademark might be limited to the geographic area that the business has used the trademark or is able to establish that it has a reputation in that trademark. Now, this can significantly reduce the scope of protection and enforceability of an unregistered trademark against other traders. Another benefit to registration is that IPONS's public register of trademarks can also serve as a deterrent. So if another party is looking at adopting a new trademark, they can carry out a quick search of the IPONS database and clearly see your rights in the trademark listed on the database, which can serve to warn them to select an alternative trademark. Later filed applications for similar trademarks will also be blocked by your registration. So IPONS will generally refuse to accept a trademark application that is similar to an earlier registered trademark, which can be another benefit of having your trademark on the register. It is possible to rely on unregistered trademark rights to oppose an application once it is accepted, but having your trademark on the register already means that the new application will likely be automatically blocked by the IPONS examiner rather than you needing to take steps to oppose it. Another benefit as well is that when it comes to online brand protection programs, such as Amazon's brand registry, it's often a requirement that your trademark is registered in order for you to access these tools. And the last thing that I wanted to mention while we're talking about unregistered versus registered trademarks is that it's important to know which symbols you're entitled to use when you're using your branding. So the TM or trademark symbol can be used as soon as you start using a trademark, whether you've applied to register it or not. The R symbol, which stands for registered, on the other hand, that one can only be used once the trademark has been successfully registered with IPONS. So you'll want to be careful to make sure that you're using the correct symbol in the correct circumstances. Now, I'll pass back to you, Graci, to answer the question, should I register my trademark as a word or register my whole logo?
Thanks, Rebecca. So another common question we get. So when you apply to register your trademark, you have the option to choose between a plain word format or an image, logo, or stylized representation. When we talk about a word mark, we're referring to the registration of your trademark in a plain text format without any specific font or styling. So this can include letters, numbers, words, phrases, or a combination of these elements. So one of the key benefits of registering a word mark is that it offers broad protection for your trademark without being limited to any specific visual representation like the font, color, or size. This flexibility is particularly beneficial for future-proofing your brand. So for example, if you decide to update your logo or change the styling of your branding, your wordmark registration remains valid and it doesn't become outdated. So think about how Microsoft's Windows logo has evolved over time while the name Windows has remained consistent. It's important though to keep in mind that because a wordmark provides such broad protection, if your trademark consists of terms that are common in your industry or descriptive of your goods or services, obtaining broad protection can be challenging. So these terms are often essential for other businesses, and no single trader should have exclusive rights over them. So if your trademark falls into this category, it might be difficult to secure the level of protection that you're seeking. On the other hand, when you apply to register a logo, that can take several forms. It might be just an image, a combination of words in an image, or words presented in a unique font, like the iconic Coca-Cola logo. Registering a logo gives you protection for the entire design, including all the distinctive visual elements it features. This means that you're basically safeguarding the complete look and feel of your brand's logo. Now, when it comes to the words in your logo, like your brand name, the protection offered by a logo registration is more limited compared to a broad word mark registration. This is because protection is for the entire design, including its unique visual features. So I mentioned before that it can be challenging to register a word mark if your trademark includes common or descriptive terms that other traders in your industry might need. In this case, applying for a logo version of your trademark can be a more viable or practical option for you. If the visual elements of your logo are distinctive enough, this approach or strategy might help you secure registration for your brand overall. So to look at it from a strategic perspective, many businesses incorporate both word and logo elements into their branding. Typically, the word mark is how consumers identify the brand. Think of Nike alongside the iconic swoosh logo, or the distinctive fonts used by brands like Disney and Coca-Cola. For optimal protection, a business will want to register both the word mark and the logo used in their branding, especially if the logo has unique visual features that should be protected as well. That said, depending on your branding strategy, there might be instances where securing broad word mark protection is not feasible. In those cases, pursuing logo protection could be your best option. Now, if you opt to register your logo alone, there are some potential limitations that you should be aware of. So firstly, enforcing trademark rights can be more challenging compared to a word mark registration, especially if the words in your logo are descriptive or commonly used terms like we discussed. So if your branding leans more towards non-distinctive elements, like including descriptive or common terms, you might have to accept that other businesses can use similar terms for their own goods and services. This means your exclusive rights to your branding will be more restricted. To maximize protection, it's best to choose a trademark that is unique and distinctive within your industry from the outset. One important question to ask yourself is whether other businesses without any improper motive might want to use the same term to describe their similar activities. If the answer is yes, it might be wise to adopt a more distinctive and unique brand. Also keep in mind that if you rely solely on a logo registration, any updates or changes to your logo or branding could lead to your registration becoming outdated. This could make it vulnerable to revocation due to non-use if you're not using the logo as it was originally registered. All right, thanks, Beck. I'll pass it back to you.
Thank you. Now, the next question, and this is one that we get a lot, is what can I do if the trademark I want is already taken? Now, in terms of the first steps here, I would say you really need to determine whether the trademark actually is unavailable. Now, sometimes this is obvious, but in many cases, there can be a lot of different aspects that should be considered. So a trademark may be unavailable for your use and registration if an earlier trademark registration exists for a substantially identical or deceptively similar trademark, and that earlier trademark is registered in relation to similar or closely related goods or services. Now, the test for substantially identical takes into account the essential features of the marks in a side-by-side comparison. And on the other hand, the test for deceptively similar does not involve a side-by-side comparison, but is instead focused on the impression left by the marks. So it takes into account the imperfect recollection of consumers. So to determine whether your trademark really is unavailable, it should be assessed against the earlier trademark with these tests in mind. This is the process that an IPONS examiner will go through in examining your trademark application and deciding whether it can be accepted for registration. It's really important to remember that trademarks can coexist for unrelated goods and services, even if the trademarks themselves are identical. Now, the basis for this is that a consumer is unlikely to be confused into believing that a provider of, say, motor oil, for example, is the same party providing beverages under the same trademark. Now, if your application to register your trademark is blocked by an earlier similar trademark, there may be options available to you for attempting to overcome the objection. So there's a lot of different things you can consider here. Now, first of all, if you believe the trademark examiner at IPONS has made an incorrect assessment of your trademark and that the two trademarks are not deceptively similar and should be able to coexist, one option is to file submissions arguing against the objection. So submissions are essentially legal arguments put forward to the examiner to support your view that the trademark should be accepted and should be able to coexist with the earlier mark without a risk of consumer confusion. Another option is to approach the owner of the earlier trademark to see if they would be willing to provide consent to your use and registration of your trademark. If they provide the requested consent, this can be filed by way of a letter with IPONS and will generally result in your trademark being accepted despite that earlier trademark conflict. Now, requesting consent can be a viable option if the parties are not competitors and really are capable of coexisting without commercial conflict. There is always some risk involved in approaching the owner of a cited mark, as it puts them on notice of your activities and intentions, and it might actually prompt them to object to your use and registration of the trademark. So it's something that needs to be weighed up carefully. Now, another option to consider as well is if you have already been using your trademark in the marketplace for a period of time, you might actually be able to overcome the citation of an earlier trademark on the basis of your honest concurrent use. That is, that you adopted your trademark honestly and that you've been using it concurrently alongside the earlier trademark for a period of time without consumer confusion occurring. Now, another angle to consider is whether the earlier trademark might be vulnerable to attack. So a trademark registration may become vulnerable to removal for non-use if it hasn't been used for a 3-year period. What this means is that if an earlier trademark is blocking your application and it doesn't appear to be in use anymore, this can be a strategy for removing it from the register so that it no longer forms an obstacle to your application. Now, threats of non-use proceedings can also sometimes be used as leverage for obtaining consent. So, for example, you may negotiate an agreement where you agree to refrain from applying to remove a trademark for non-use, and in exchange, the owner agrees to provide consent to your application. Another way that you might be able to attack or challenge a trademark that is blocking your application is if it hasn't yet been registered and is still in the opposition period. So if you can successfully oppose the application, it will be rejected for registration and will no longer form an obstacle to your application. This strategy is most likely to be relevant for you if you have prior use of your trademark before the filing date of the mark that is blocking your application. Now, to summarize, there are several different avenues and options you can explore if you think the trademark you want to use and register is already taken by someone else. Sometimes there is a clear strategy that is the way to go. Sometimes it's a combination of strategies. So it's always worthwhile to consider these carefully and get advice where needed. Ultimately, though, you may need to be prepared with a backup plan if your trademark really is taken by another trader and there doesn't seem to be a way around it. So make sure you do your due diligence when you're selecting a new trademark and be ready to change strategy if your first choice is unavailable. If you use a trademark that someone else owns, you may be at risk of them taking legal action against you. Something else to bear in mind as well on that point, if you're planning on expanding internationally, you may want to consider an international knockout search before adopting your trademark. This can save you the disappointment later if you go through the effort of securing your trademark in New Zealand, only to find out that when you're ready for overseas expansion, you can't use the same brand in one of your key overseas markets. All right. Next, Gracie, I'll hand back to you to answer the question, how do I stop someone who is copying my trademark?
Thanks, Rebecca. So to address infringement here, it's essential to first recognize that it's happening. So the first step really is to fully understand your IP rights, which will help you identify any conduct that infringes upon them. So really important to keep your trademark portfolio up to date here. Make sure it accurately reflects the scope of your goods and services, any variations of your logos, and make sure renewals are made on time. Next thing is to actively monitor the marketplace for unauthorized use of your trademark. So setting up Google alerts and keeping an eye on online platforms like social media and e-commerce sites can be really effective strategies here. Another tip is regularly checking the trademark register for new filings in your industry can help you respond swiftly to potential issues. So if someone applies for a trademark similar to yours, you have the chance then to challenge it when the application is advertised for opposition. Lastly, when you become aware of any sort of infringement, act quickly. Allowing a third party to use a trademark without challenge for an extended period can complicate your ability to address the issue later on. So what legal protections are available to you as a brand owner if someone copies your trademark? Well, there are a few different avenues. If your trademark is registered, you can take action for trademark infringement under the Trademarks Act in New Zealand. New Zealand consumer and fair trading laws also provide protection against things like misleading conduct, false information, or unfair practices, which can often be the case when your trademark has been copied. There's also the common law tort of passing off, which addresses situations where one trader's goods or services are presented as those of another. This can happen if another trader uses your trademark without permission. Lastly, if it's your logo that has been copied, this might amount to copyright infringement under the Copyright Act. So we know if your trademark is copied, there are various legal actions you can pursue, like we just discussed. These options aren't mutually exclusive. There might be some overlap, and certain avenues may be stronger than others, depending on your specific situation. In some cases, certain protections I mentioned might not apply at all. For that reason, it's really important to get legal advice to know where you stand. Your legal team can help you make sure that any allegations that you make are valid and that you avoid making unjustified threats. So, for example, you can't claim trademark infringement if your trademark is unregistered. If you need to take action, the first step usually is to send a cease and desist letter. This letter informs the other party of your rights. It sets out their conduct that breaches those rights and outlines the remedies available to you if they continue. If the conduct doesn't stop, you might then need to consider escalating the matter by initiating court proceedings. Now, if someone has copied your trademark and applied to register with IPONS, you have another option, which is to challenge this through trademark opposition proceedings with IPONS, like we discussed. So if you successfully oppose the application, this means that the trademark won't be registered. Opposition proceedings take place before IPONS rather than in court, which makes them generally more accessible and affordable than court actions. So it can be a good avenue for challenging a third party. And like Rebecca mentioned earlier, you can base your opposition on various grounds, which can include both registered and unregistered trademarks. Finally, it's also worth mentioning some other frameworks or policies that might help you challenge a third party that has copied your trademark, depending on the platform involved. If there are issues with another party using your trademark as a domain name, you might be able to resolve this through the UDRP, which is the Uniform Domain Name Dispute Resolution Policy, or New Zealand's DRSP, their Dispute Resolution Service Policy. Various social media platforms like Facebook and Instagram also have their own IP policies that allow you to report infringements or violations of your IP rights. Finally, there's some e-commerce platforms that also offer IP protection programs to assist brand owners, which includes Amazon's brand registry. All right, I will leave it with you, Rebecca, to cover off the last part of the presentation on global protection.
Thanks, Gracie. So let's talk about international trademark protection. So the first and most important thing I think to be aware of is that trademark rights exist on a country by country basis. So that means that your trademark protection in New Zealand is certainly a great start, but it's only the first step for your business if you have plans for international expansion. Now, generally, there are two options for putting trademark protection in place overseas. So the first option is filing direct national applications in the countries of interest to you. With this option, each registration is filed separately. So they all sit separately. Maintenance is also separate, which means that renewals are carried out individually. Any updates to ownership, all that type of thing is all carried out country by country with each trademark right. The direct national route generally involves engaging a legal representative in each country of interest to file the applications directly with the National Trademarks Office in that country on your behalf. Now, the second option is filing an international application via the Madrid Protocol. So the Madrid Protocol is a framework for registering trademarks in multiple countries at the same time. So the way that it works is there is one parent or umbrella registration, and each country of interest is listed as a designated country under that international application. Now, because each designated country is essentially linked to the one registration, maintenance such as renewals or ownership updates is a lot more streamlined than if you're dealing with a portfolio of direct national applications. The Madrid Protocol can be a really cost-effective strategy for expanding your protection into multiple countries at the same time, especially as it doesn't generally require representatives in each country, which can significantly reduce the costs. Now, a couple of other quick points about international protection. If you file internationally within 6 months of your New Zealand filing date, you can take advantage of an international agreement where you're able to essentially backdate your international protection to claim priority from your earlier New Zealand filing date. Now, this can be a really useful way to stagger the costs of your international protection, or also to give the business more time to develop and see which markets are emerging as priorities for you. If you have plans for international expansion, we generally recommend getting your trademark applications underway as soon as possible. Now, this can become particularly important in countries that follow first to file trademark systems, where unregistered trademark rights might not be recognized. An example of this is in China, which follows a first to file system. Now, you'll also want to get things underway early in countries that have lengthy examination delays. For example, in Canada at the moment, it's taking more than 2 years to get to the first examination stage of a trademark application. So it's good to get the ball rolling on these things if those are future intended markets for you. Now, trademark procedures can vary in each country, and there are quite a few different requirements that can catch you out if you're not familiar with the different systems adopted by each country. Some countries require careful consideration of the filing basis for your application, and some require that your goods and services specification be drafted in a very particular way to comply with local requirements. Timeframes also vary greatly from country to country. Like I touched on, the timeframe from filing through to registration can take as little as 4 months, or in some other countries, it can take up to 2 or 3 years or more. It's really worthwhile engaging the assistance of a trademark professional who is experienced in international trademark protection to help you navigate these complexities and devise an international filing strategy that is tailored to your business and your expansion plans. All right, over to you.
Wonderful. Thanks, Rebecca. So that includes the main part of our webinar. You might find our publication useful, which is a guide to trademark essentials in New Zealand. So you can get that through the handout panel or by scanning the QR code on your screen. You might also be interested in our upcoming event in New Zealand, which is on sweat equity and startup valuations, which will be on the 29th of October at 1 p.m. All right, so we're going to answer your questions shortly. And while you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100 plus specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. So our team can assist you with things like unlimited document drafting and reviewing of business contracts. Unlimited legal advice consultations are included, along with unlimited domestic trademark registration and a lot more. So as a LegalVision member, you really won't need to worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. We also offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. If you're interested and to learn more about how membership or desk extension can help you, feel free to request a free consultation when the survey appears at the end of this webinar. All right, we'll get into some questions now. So we've got a pre-submitted one here that I might give to you, Rebecca. And the question is, if you update your logo design, not the name, how essential is it to update your trademark registration?
Thanks, Gracie. Yeah, that's a really good question. Now, there's two things to think about here. First of all, if you change your logo in a way that substantially differs from your trademark registration, your protection granted by that trademark registration might not cover you for the way that you're using the trademark. So in terms of inadvertently infringing a third-party trademark, you might not be able to rely on your registration as a defense to infringement. So it's always safest to use your trademark exactly as you've registered it, and also to update it if you do change it. Now, the other thing to bear in mind as well is that if you're not using your trademark exactly as it's registered, it might become vulnerable to removal for non-use. So we talked about how trademark registrations become subject to a use requirement, or they become vulnerable to removal if they're not used for a 3-year period. If you're not using your trademark as you've registered it, so in that particular logo design, then your trademark might inadvertently become vulnerable to removal. So it's always worthwhile to keep it up to date and to make sure that you have that protection in place and that you're not inadvertently eroding your rights. In terms of very minor changes to a logo, it might actually be possible to update the registration by applying to IPONs if it is a very small change and it doesn't affect the substantial identity of the trademark itself. But in any case where it is a substantial change or it really adds something different to the logo, then it would likely need to be filed as a new application to protect that new logo. Anything else to add on that, Gracie?
No, I think you covered it off that really well. Thanks, cool. Rebecca.
I'll pass the next one to you.
Yeah,
so
I can take this one.
Question is, if I've got the name and logo or image only registered, do I still need to register my other logo, which combines the image and the word?
Yes, that's another really common question we get. So I'd say if you're using a different version of your logo, which combines your name or a word and an image, this would technically be treated as a separate trademark. So having the word and image registered separately still will provide you with some protection. Though best practice is to register each trademark that you're using for the most comprehensive or robust protection for your brand, since registering the combined logo will provide you with rights to that specific representation. Did you want to take the next one, Rebecca?
Yeah, we've had a live one come through, which is a really good question as well. So the question is, does the Madrid Protocol have a list of countries it covers, or do you have to choose which ones you desire? And the answer to that is a little bit of both. So there are Most countries in the world these days, the vast majority are members of the Madrid Protocol. There's still a few countries that are in the process of joining or haven't yet joined, such as South Africa, Hong Kong, off the top of my head, to name a couple. But most countries are members of the Madrid Protocol. What that means is that you're able to designate them under a Madrid Protocol international application, but it doesn't mean that they are automatically all designated and all covered anytime you file a Madrid Protocol application. So you still need to take that extra step of choosing the countries that you want to list under your international application. And the fees associated with that on a per country basis as well. So, if you were to tick all of the boxes and file in every country that was a Madrid Protocol member, the costs are likely to be completely prohibitive. So yeah, it is on a country by country basis, but the country has to be a member of the Madrid Protocol for you to be able to designate them. Otherwise, if they're not a member of the Madrid Protocol, you can still file a direct national application in that country. Now, the other part to that question was, does the 2-year waiting list in Canada get backdated once the trademark is accepted? And the answer is essentially yes. So once you file your application, you secure your priority date. And that means that anyone who files later than you will be blocked by your application on the register. So everything essentially will go back to that priority date and the filing date when you secure the trademark. So that would likely be the deemed date of registration once you ultimately achieve registration of the trademark. So that priority date or the filing date becomes very important. And like I mentioned, your filing date will either be the date that you filed it, or if you're claiming that 6-month priority period that I spoke about earlier, then that would essentially be your priority date. So you'll be able to get an even earlier date against the application. All right, over to you, Gracie.
Thank you. So another pre-submitted question we have here is, apart from business names, what other things are important for businesses to consider having trademark? That's a great question. So from experience, it's pretty common for businesses to protect their unique logos as well. So this could be an image, a mix of words in an image, or even just words in a unique font, like we talked about earlier. If you've got any catchy phrases for your brand, so think about Nike's "Just Do It" slogan, you might want to look into protecting those too. Some companies also use specific names for their products, like Apple's AirPods or Microsoft's PowerPoint. So I'd say when you're thinking about trademarks beyond just your business name, keep an eye on or think about all the other branding elements that you use. Like I mentioned, best practice is to register each trademark you're using to really comprehensively protect your brand. I think we might have time for one or two more. If you want to take the next one.
I might grab this live question that's just come through. How hard is it to trademark everyday words? And there's an example in there. I won't read the trademark out in case you're not comfortable with that being shared with the rest of the audience. But this person sounds like they've applied to register a trademark and then got told everyday words get difficult in the world of trademarks. Now, it really depends on how everyday or descriptive that word is in relation to the goods or services that you're applying to register it for. So something that's entirely descriptive, like, Auckland Mechanic Services, if you're running a mechanic in Auckland, obviously directly descriptive, other traders are going to need to use the same or similar term to describe their similar services. So you can't have a monopoly in that term. When you have, there's often trademarks that fall into kind of a gray area where there might be certain characteristics, or the trademark might allude to potential characteristics of the goods or services, but it's not directly descriptive, or you've put it together in a way that is unique and it's memorable. And in those cases where there's that gray area, there's often a good chance of putting forward some arguments that the trademark should be considered inherently distinctive and capable of registration. And the test really comes back to, are other traders going to need to use the same or similar term to describe the same or similar services. So there's definitely a few things to consider. I'd encourage you to book in for our free consultation, and we'd be happy to discuss that in more detail with you. Now, that is all the time that we have for today. Sorry if we haven't answered your questions, but please submit your details in the survey at the end for assistance with any questions we didn't answer, or to learn more about how our membership can help you. Excuse me. And while this is a free webinar, we value your feedback, so please take 30 seconds to complete the survey at the end of the webinar. Thanks very much for joining us.
Thanks, everyone. Have a good day.